You thought that we were done talking about Karen Read since she got acquitted. Of course not. There's a civil case going on because the family, they originally tried to sue in the middle of August 26th of 2024. So during the end of her original trial, which was a hung jury, which led to a mistrial. So that means they got to do another 3-month trial all over again. How fun for everybody. The second trial ended up costing taxpayers $1.4 million from the prosecution alone. That was taxpayer dollars, and that's going to come up later. But we're going to talk about the pre-trial that happened. So it was about a 3.5 hour trial, talking about dates and motions and just a bunch of criminal law arguments, or not criminal law, but law arguments, things that had happened in other court cases, arguing case law. And I'm going to try to condense it for you in about 30 minutes. Let's go. So right off the bat, let's get it out of the way. If she was found acquitted, she's not guilty of the crime that she was charged with, then how is she getting sued for death again, for a wrongful death lawsuit? Well, it's because the reason why double jeopardy doesn't apply here is, one, double jeopardy is actually a criminal thing, but also it's a wrongful death, not a first degree, second degree murder or manslaughter charge. So it's not the same charge. It's technically for the same thing. It's saying that this person is responsible, Karen Read is responsible for somebody else's death. Case represents it, and that's why it applies here. Trying to convince the judge, who was just mad at everybody, by the way. The judge over here was going, constantly. And it's because there's already a large number of people involved in this, because Karen Read is not the only one getting charged this time. She's getting charged not only for wrongful death, but also for emotional distress, along with the 2 bars who were involved in the trial, C.F. McCarthy's and the Waterfall. They are being charged with, in her trial, the only thing that she had been criminally convicted of was driving under the influence. She was overserved by these 2 establishments definitively, because there are videos that we saw in the trial of Karen Read at those 2 bars. And the O'Keefe family, so Margaret O'Keefe, John O'Keefe, the deceased person's mother, John O'Keefe, the father, and then the niece and John O'Keefe's estate are involved. Now, if you're wondering why John O'Keefe's nephew is not involved with this, it is because they said he is not on the same level as the niece, because the niece was the only person home the night/morning of the incident, and Karen Read had woken her up out of a sleep, freaking out about John being missing. So they said that was emotional distress on her, and then finding the person who had adopted her and was taking care of her dead shortly after she had already suffered from the loss of both parents not too long before. And then seeing him in the hospital in his horrible state that he was in, they said there was emotional trauma that needs to be compensated for, is the plaintiff's defense. However, C.F. McCarthy's and the Waterfall are saying that they are not responsible for this, and Karen Read is saying, I'm not responsible for the death of John O'Keefe. I'm already doing this stuff for the DUI. And Karen Read, according to Alan Jackson, who's returning to be a part of her defense team, said that she's not only on the defense, because one of the motions that the wonderfully accented lawyer that she has, Seglison, I think that's how you pronounce it. I will put his picture and name here, and if there's any correction, I will also put that there. But he had a wonderful accent, not a Boston accent. I don't know where it's from, but it was amazing. And he's the main speaking lawyer, and he said that he wants the emotional distress stuff nixed, and that they wanted that thrown out. And as far as the wrongful death lawsuit, he basically kind of used the plaintiff's lawyer's words against them, because he said, yeah, here's all the things that they listed, And that is why we want to bring in, get ready for this, 8 more people into the wrongful death lawsuit, as in Karen Read is countersuing them for being a part of why she's there to begin with. So the people who are involved are the Massachusetts police, like as a whole, the Massachusetts State Police as a whole. And she specifically was going after Lieutenant Brian Tully, who was already removed from his position, Sergeant Yuri Buchanan, who was also dropped from his original position, and former Trooper Michael Proctor. Now, Proctor had already been fired, like fully let go from his position. He's currently in appeals for that, but he was fired, so he is not being completely directed in this, but he's still pseudo being dragged into it. But also, other people that Karen Read says are part of the reason why she's here to begin with, and those are Brian Higgins, Brian and Nicole Albert, and Jen and Matt McCabe. She said that these 5 individuals, because for those of you who don't know, John O'Keefe was found deceased on the Alberts lawn, and Karen Read had dropped him off there for an after party after they got done at the bars, and then the next morning, he's dead on their lawn. Brian Albert is a Boston police officer, and so was John O'Keefe. And he did not go out to help a fellow officer, didn't go to check on him, didn't provide first aid, first responder, life-saving services that he was trained in. No. Him and Nicole knew about it based on phone calls that Jen McCabe, who was there that morning driving around with Karen Read, finding him, and they knew what was going on their lawn. There were emergency sirens and vehicles in the morning. They knew something was happening outside. Didn't even check. And she said that something happened to John O'Keefe, that he was beaten to death. Either he was attacked by a dog based on the definitive dog bite wounds on his arm, and the Alberts had a German Shepherd named Chloe. I say had because right after John O'Keefe was found, they rehomed Chloe to Vermont. And Chloe, the German Shepherd, was known to be aggressive towards strangers and other animals. It was John O'Keefe's first time being at the Alberts' house the night he was dropped off. Also, there were shoes missing. There was hats missing. He wasn't dressed to be out wandering in the weather. He was just wearing a hoodie in the freezing cold January in Massachusetts. And so all of that to say that Karen Read is accusing these specific people in the police department and the Massachusetts State Police as a whole. There's going to be some tidbit at the end. Just wait for that. But them and the Alberts and the McCabes they knew what happened to John O'Keefe. They may have even participated in what happened to John O'Keefe, that he had died from blunt force trauma to the back of the head, was rendered unconscious, and then left outside in the snow overnight. And he didn't show a lot of signs of hypothermia, but it was brought up in the coroner's notes. But the coroner, the medical examiner, multiple other doctors, biomedical engineers had said that John O'Keefe's injuries were not consistent with being hit by a car. And that is what the O'Keefe family and previously the prosecution had accused. They said that Karen Read backed into John O'Keefe with her car and left him to die in the Alberts' yard. He wasn't hit by a car, so how do we get to being here? And that there were a lot of suspicious things happening with the whole investigation. If you didn't see any of my previous stuff, I will link to all of it below. But we're talking like unlabeled red Solo cups with open tops being used to collect blood evidence. And the snow was taken away around the crime scene with a leaf blower. Okay, if you need more than that to see, it went downhill from there. Okay, there was stuff that wasn't labeled into evidence. There were the witnesses, the McCabes and the Alberts particularly, were not isolated from each other to take witness statements. They were all together all the time. Jen McCabe was in all of their ish. And there was a lot of suspicious deleted calls. Oh, we got a new phone right before we were going to have to turn it over to the police, so all that information is gone. And the number of accused butt dials was ridiculous. And Karen Reed's like, I'm not dealing with this. If there is a wrongful death happening here, and they're responsible, not me. And the motion and the judge was simply like, we'll deal with these additional possible plaintiffs at a different time. Did you know about this? This is what he said to the plaintiff's lawyer. Like, no, I wish I would have known that they wanted to drag 8 more people into this. But judge was not pleased. So then we continue with the dismissal of the emotional distress. Karen Reed's defense said that the family of John O'Keefe's family did not suffer acute pain or any particularly strong pain, stronger than anybody else who lost a loved one. That yes, losing a loved one hurts. There is no way to make that pain go away. But it doesn't mean that Karen Reed is responsible for that pain. They want to bring all those other people in who are, according to them, the actual cause, and that they conspired against Karen Reed to make her the patsy in this case. And it didn't work in the criminal trial. And the O'Keefe family, particularly John O'Keefe's mother, really had shown in the trial just general disdain and did not like Karen Reed to begin with. So that's probably not great. And they said that they didn't suffer any more acute emotional damage. Again, they were arguing case law, saying that because they saw him in the hospital after he was already pronounced dead, they didn't see him on the scene like Karen Reed did. They didn't see him getting taken to the hospital. They weren't there to see the crime happen. And they say neither was Karen Reed. So their emotional damage is just normal pain of loss, nothing more. The plaintiff's attorney was citing something, and this was a big deal, specifically called the Camino case. The Camino case, he said, the father didn't find out his son had died in a car crash, car is a vehicle, until 7 hours after he had been in the hospital and pronounced dead. And that is what they said. They said, and he still got emotional distress just because somebody wasn't there at the time of the accident to see the accident happen doesn't mean that they weren't caused additional emotional distress. The niece was caused distress the whole day from when Karen Reed woke her up out of a dead sleep to scream that John was missing, what could have happened to him, saying things like, maybe I hit him, maybe he got hit by a plow, blah, blah, blah. Although this had already been explained as being a trauma response, because she was freaking out. And they're saying that her freaking out and upsetting to the niece was additional emotional distress that she didn't need to suffer. However, in the Camino case, the defense pointed out to the judge, Your Honor, they mentioned the car crash with the son. What they didn't tell you is that the father in that case was in that car crash. He saw the accident happen. He saw his son immediately after, when he kind of staggered up, whatever, and saw his son in a horrible state at the scene of the crime. So if they're trying to say that is a basis for emotional distress, again, the O'Keefe family members were not at the scene like in the Camino case. So that's really null and void, and they are misstating case law. The judge took everything under submission, which, if you don't know, that means they got to go think about it. They got to read the case law that was presented and determine the arguments. And also, he has to now consider these other defendants that he seemed flustered because what the defense said made sense, but it's annoying, and that makes everything so much worse to try to coordinate with so many other lawyers with scheduling and calendar dates, etc. And that is also towards the end of the of the trial case. The judge, had said, he seemed like he was kind of speaking to the cameras, to us, the outside audience, but also to the O'Keefe family, because he was saying things along the lines of, I need you to understand that civil litigation doesn't bring back a loved one. It doesn't take away the hurt that you feel. And please understand that what is very, very likely is that we will not see an actual official trial date of litigation happening until 2026, 2027, and maybe even into 2028, depending on how all of this plays out. And that's going to be extensive and expensive, and maybe you should consider settling or working something out or dismissing the case because of how much more, like, you need to consider, is this going to actually be worth the stress and the time? Because there's a chance that you don't get the results you want, and it's might not be worth it to you. And to me, this is FCA speculation here, I think that he wanted them to really understand that in the criminal trial, the prosecution, as I said, the $1.4 million, law is expensive. And that is the suckiest thing about it, is that to defend yourself, you have to put yourself in debt or already have like millions of disposable income to adequately defend yourself. Most people get convicted because they just can't counter the amount of money, taxpayer dollars, that the prosecution has access to for flying in witnesses and experts, etc. And he was explaining to them that this is coming out of their pocket. There is no taxpayer like money pool to dip from. This is just going to be against their bank accounts. And depending on how many lawyers get dragged into this, there's going to also be, every time they correspond with the other lawyers, do depositions, do charge accounts, anything like that, that's case related, they're going to get charged a fee. I also see the O'Keefe family's point of view of, like I said, they already didn't like Karen Read, and they lost John, and they want justice, and they feel like they didn't get it with Karen Read's acquittal. So where are they supposed to go? And if you're wondering, well, why don't they just charge one of these other people who, like, if he was beaten up and he was possibly in their house and stuff? Well, one, because it's a little too late to charge them with that. It's like, there is no statute of limitation on murder. However, it's very, very hard and very, very unlikely. Whatever the prosecution had for their attack on Karen Read, they put into Karen Read. And so anybody else who they try to charge with the same thing, when there already wasn't a, like in the Adelson case, there were multiple people charged for the same death, because they were all indicted from the beginning and charged from the beginning as being a part of the conspiracy. In the Karen Read thing, it was just Karen Read as a solo target. That changes the dynamic greatly, because every other defense team is just going to be able to go, hey, they didn't get a conviction over here, so now they're reaching for straws. They're just trying to go throw the spaghetti at the wall and see what sticks. My client didn't have anything to do with this, and anything that Karen Read used to defend herself, they're going to be able to say there was no conclusive evidence that there was a beating. If somebody's dog went after them, that's not like, say, Brian Higgins' fault. If somebody's dog was aggressive and he was at their house that night, like, those aren't correlated to he did something. So it's just they almost never go after another person if their original target didn't work, because they're just not going to sink those resources into what's more than likely going to be another fail thing. So the O'Keeffes are like, where's our justice? So civil litigation seems like the way that they're going to get it. And because the bar is much lower, it's just, this person probably did this, instead of beyond a reasonable doubt. And the judge has to take everything, and the jury has to take everything as true in civil litigation. And then the people have to argue it out. And you kind of basically have the opposite of criminal trial, where you're trying to prove yourself innocent. Karen Read has to prove something in this case, that she's not guilty. She's guilty until proven not guilty. All bar is concerned by itself. In the video footage that we have seen, Karen Read wasn't served at that bar. So how can she be charged with how can that bar be charged with over serving her when they didn't serve her? So that's not going to work out well for them. And also, there were multiple people who were talking in close proximity to Karen Read, who knew her outside of the bar, who's been with her when she was sober. And they said that she acted fine. She didn't act drunk. They didn't perceive her to be intoxicated. She wasn't slurring her words. She was completing her sentences, completing her thoughts, staying on topic, wasn't acting wild, belligerent, or unusual in any way. They were all just chatting. And if somebody's close friend isn't going to perceive them as being super intoxicated or over intoxicated, the bartender, who is not in close association with them, is not going to pick up that they've had too much and need to be cut off either. Again, because there's a lot of evidence that says that that John O'Keefe wasn't hit with a car, how are they going to go with she was intoxicated and hit him with a car? And if they try to say, well, she was driving under the influence, okay, she's already doing that. So the bars wanted to be dismissed and were basically just joining in on Karen Read's thing. The last little tidbit that I will say to this is that yet another officer has been eradicated through the Karen Read trial aftermath. Former officer Kelly Dever has officially resigned from the Boston, Massachusetts Police Department because she's an unreliable person. If you don't remember her, she originally told the FBI that she had seen Brian Higgins and Ken Berkowitz in the Sallyport, a garage at the police department, with Karen Read's SUV for, quote, a wildly long time. But then she recanted that and said that she made a false memory. If you make a false memory as a law enforcement officer, you don't get to be a law enforcement officer anymore, because there are 0 positions that I can think of where you're not going to get called onto the stand. Did you write a report? Well, how do we know that this is accurate? She just makes up memory. She just makes up facts and things. She can't collect evidence. Was this evidence collected with the proper processes? Is this actual evidence that was at the scene, as she allegedly says? Are these reports that she took of witness statements accurate, or did she just make up parts of them with her false memory creation again? That's what every defense attorney is going to say against any time she goes on the stand. So, effectively ending her own career while kind of trying to save it, we have yet another person finally being held accountable for being poopy at their job in the Massachusetts Police Departments. I will see you all in the next video. Bye!